Okay, let's call this meeting of the full committee Judiciary Non Civil to order. We've got a few measures to consider here today. I'm going to go a little out of order and take liberty and have Chairman Lumsden come in and present House Bill 410 first. If I could ask before we start, Representative Saines, would you mind giving a word of thanks?
Sure. Let us bow our heads. Dear Father, thank you for bringing us here today. Let us remember that through your grace, we are here to institute the policies that keep Georgia safe. Let us gain wisdom from you and you alone. In your name we pray, amen.
Thank you, Representative Saines. Okay, most all of these, well, every one of these pieces of legislation have went through the subcommittee process, and we have picked these apart. Thanks in large part to Chairman Reeves and Chairman Setzler and members of the committee for making sure that we get these pieces of legislation correct. This piece here is House Bill 410. It's a fairly simple bill. One thing I would like to say about this, that we have requested a fiscal note on this. We haven't got it yet, but I did confirm that according to the rules, we can't move on the piece on the floor without a fiscal note. We can move in committee. That's according to our House rules. So with that said, I'm going to turn this over to Chairman Lumsden and present this bill. I appreciate you, Chairman.
Afternoon, Mr. Chairman, members of the committee. I bring to you House Bill 410. We're working from LC 412899. This is a department bill request from the Georgia Bureau of Investigation. This bill changes nothing about current law except that it transfers the responsibility for regulating bingo from the GBI to the Secretary of State's office. That is what the bill does. I'll be glad to answer any questions.
So I think the invitation has been extended to the Secretary of State's office to come and testify on in their interest in this bill, and they haven't made it up until even now. But I did receive a text from Sam Teasley from the Secretary of State's office today. He's out sick, and I asked if he had any interest in weighing in on the bill, and his response is that he just wants to make sure that this is taken into consideration during appropriations, because they will be taking on this role, and it's being removed from the GBI. That was the only context that they gave or input they gave. So we did reach out on numerous occasions to make sure that if they had any input, to give it to us.
Yeah, just as a little bit of background, the GBI has had this responsibility for many decades. I'm not sure of the origins, but when you look at what is required, the Secretary of State's office is a regulatory agency. The GBI is an investigative agency with law enforcement, plays a major law enforcement role. And this is really just about manpower, because even though this is a regulatory matter, it does take manpower away from the investigative work that the GBI does. So this just seems to be a logical move to move the regulatory responsibility for this from the GBI to the Secretary of State's office.
And I agree with you, Mr. Chairman. One thing I did also verify, first off, I didn't know that we regulated bingo in the state of Georgia until we brought this bill. But secondly, we actually have a member in the House that is a licensed operator bingo operator, and that happens to be Chairman England. So I approached Chairman England to find out what the ins and outs of this were, and they have to perform a criminal background check on these operators, and that will still be performed by the GBI. So the only thing that's happening here is that we're removing this regulation over to Secretary of State, much like many of the other licenses that they regulate today. So I appreciate you bringing the bill, Chairman.
All right.
I'm going to open up. We don't have anybody online.
We do have representatives of the GBI outside if you needed to ask them of any questions of them.
I'm going to ask the committee, does anybody have any questions of Chairman Lumsden? And we have nobody else signed up to speak to this bill. So If there are no questions and no discussion about this bill, I'm going to call the question. For all those in favor of House Bill 410 with LC 412899, signify by saying aye. Oh, my apologies. My apologies. I'm getting ahead of myself. I'll take a motion to pass. Thank you. So we got a second. All right. So now we have a motion and a second. Let's go through that again. All those in favor of passage of House Bill 410 LC 412899 signify by saying aye.
Aye.
Any of those opposed, like sign. The measure passes on to rules. I appreciate it, Chairman Lumsden. We've got some rules forms so you can fill out, and we'll get signed for you when you get them filled out. Appreciate it, Chairman. All right, thank you. Let's go. What's the next measure we got?
Had a constituent call me first time ever. Said, I want you guys to make the driving test, the road test more rigorous than this. This kid that took it.
Representative Saines, you ready? Yes. All right, we're going to consider House Bill 258. Representative Saines, would you like to testify there from where you're sitting? All right, hold one.
It's amenable to the chair. House Bill 258.
Let me clarify this, the LC you have
Sure.
there. We got LC 280256S.
That is what I'm working with.
That's what you're working with. Okay, thank you. Now, go ahead.
So LC 258 is a response to State v. Williams. There is a case, and I'll be brief because I know it was highly vetted in subcommittee. Chairman Setzler and the committee did make a few requested changes that both simplified the bill and more directly addressed the true policy intent of it. So we took out a few statutes that already had the protection, but in State v. Williams, there was a 4-year-old girl. She was sexually molested by her grandfather, not using the legal terms that she was charged with. And the court, it was in jeopardy of getting kicked out by the court because the prosecution did not prove that the child did not consent. And in sexual battery, that is not unlike child molestation, that is not in the codified law. So this provision would allow for the prosecution to go forward without having to prove in those instances if a child is under the age of 16 that that consent is already not eligible. We did further restrict that provision by adding, for the purpose of sexual arousal, significant of offender or alleged victim, to balance the fact that we were reducing the charge or the elements of the crime by one count. We were modifying it to a more appropriate in this instance by adding that sexual arousal provision. So the chairman might want to allude further to it, but that's in gist of the bill.
I'm going to ask that the subcommittee chair, Chairman Setzler, speak to the bill, please.
Thank you, Mr. Chairman. Yeah, there was, we did do 2 hearings on this with about a week intervening time between to make.
What number are you? 6?
Number 6.
I've got you on. Okay.
With about a week of intervening time in between. There was initially 4 sections, and for purposes of clarity, the author had brought in child molestation and aggravated child molestation, which is one code section that already has the consent language is already addressed in existing law. So it was creating some confusion in committee and in terms of how it would play out in exemptions versus elements of law. So we took those out because it wasn't central to the bill. But I would say this passed out of the subcommittee 5-0, Mr. Chairman. I'm glad to speak to my perspective on a couple of policy questions if it's appropriate.
Please do.
The issue, the for example here is in the circumstances of sexual battery, which is a touch in the these intimate parts. You think about parents, giving their kids a bath, for example, so to speak. One approach we could have taken was one of an exemption for parent, guardian, or medical professional, in any legitimate hygiene or medical procedure.
Your microphone's not picking up. Either you're not, it's not, you're not getting anything. Sorry, Chairman.
Is that better, Mr. Chairman?
Yes, sir.
Must be touching the wrong mic here. Again, in those settings, sexual battery is a touch, a aggravated sexual battery is a penetration of the private parts. So you think about, putting on diaper cream for a child, you think about putting in, feminine hygiene products for a young girl, or, there's medical procedures. All of those things were contemplated. And rather than taking in the exemption route, through having a parental guardian or for legitimate hygiene purposes, we took this route of, if there's not an element of, for the purpose of sexual arousal of either the alleged offender or victim, then, consent shall not be a defense. So we took the route of this arousal element as opposed to this exemption. Either way would have worked. And it was PAC and the author that brought this particular language that accomplished that their way. So we withdrew some amendments that would have addressed that, but this is really addressing, making sure that the under 16 years of age, inability to consent is memorialized and maintained, but that addresses it in this way that someone couldn't claim that there was this sense of consent that would somehow still be available, get before the jury and kind of cloud things. So this was a way to close that loophole.
Yeah, I think also it's of note that we added that it's for sexual arousal of both the offender or the alleged victim. You want to speak at all to that?
Yes, sir. One of the and again, it makes you twist your thinking just to consider it in the Williams case. But one of the defenses raised in the Williams case was a step grandfather and a 4-year-old child, and the 4-year-old child was saying they liked it when the step grandfather was molesting them, and he said that the child liked that, and even though it was clearly child molestation, that they kind of muddied the water in making those claims. So we needed to use this, that there's no way that can be there's no way that can still be used as a defense, even if the purpose was for the arousal of a child under the age of 15. You're still going to be subject to sexual battery, in that case aggravated sexual battery.
Yeah, I know this is not a subject we like discussing, but this is an important matter so that nobody can use those as a defense of consent. So I appreciate the work that the chair has done, and also the author. Do I have any questions from the committee? I've got one. Representative Bodie?
Yes, thank you so much, Mr. Chair. And I understand the rationale behind the law. I just want to make sure that we are staying consistent with current code, because I just looked at OCGA 1664. It does, as Mr. Representative stated earlier, the current charge of child molestation does have the intent to arouse either the child or the person. But the key word I want to make sure is intent. And I don't see the word intent utilized in HB 258. And that's so critically important for the prosecution and for the defense that we have the word intent in there, because we have to look at the individual's mens rea as well. And so I would just suggest at the appropriate time, to be consistent, we need to utilize and input the word intent.
Are you suggesting we utilize the word intent versus for the purpose?
Yes. Because the way the current code reads right now, Mr. Chair, this is worded a little bit differently. In the current code with child molestation, they're utilizing the word child or the person. So we're changing lingo as well. We're using different terminology. We're using alleged offender and alleged victim. So I think it needs, just for statutory purposes, I think we need to stay consistent on what's in current code. And we also need to make sure that we somewhere put in there the word intent. I don't know exactly where, because we kind of changed the statutory construction with this particular bill, HB 258. So I just want to make sure, I'm not against it, but I just want to make sure we're in line with current code, Mr. Chair.
Thank you. Thank you, Representative Bodie.
Chairman
Sessler.
Mr. Chairman, I'm trying to find that here on my phone. I'm used to doing all my stuff, but what's the, when they use the word intent, it doesn't use the word arousal. What is the?
What it says, I can read out, Mr. Chair. It says a person, and this is OCGA 1664A, a person commits the offense of child molestation when such person, this is subsection 1, does any immoral or indecent act to or in the presence of or with any child under the age of 16 with the intent to arouse, satisfy the sexual desires of either the child or the person.
And the conduct is for. Do we have anybody from Legislative Council on here that can speak at all to this? Can you unmute yourself, Holly? I mean, I see from a matter of consistency that might work. Is the author open to?
I mean,
I'm here.
Oh, is Holly there? I'd rather her speak to it, but I believe she utilized the language that we requested, so she'd probably be, I don't see an issue, but I think she'd be in a better point of view to.
I'm looking at 1664 right now, and we could change the language if it's amenable to the committee. When the alleged victim is under the age of 16 years and the conduct is for the intent to arouse sexual desire, we can just take that exact language that Representative Bodie used from 1664 and just plug it in there. But let me finish writing it out and I can tell you, just give me a second to construct it if you guys don't want to go ahead and do it, and I will tell you what I came up with.
We'll hold on you. I got
Okay.
Chairman Reeves here. He waves. So if we input intent, I don't know if that reads just right. Let me see if I can figure this out here. Child under the age of 16 with the intent. So it would be the child.
No, it uses the word act. So it uses the word-
Just so for my question was, what if we replace the word conduct with intent? So it would read, when an alleged victim is under the age of 16 and the intent is for the purpose of sexual arousal on the part of the alleged offender.
And I guess, Mr. Chair, is it okay we can have some open dialogue?
Yeah, yes, let's
Yeah.
how about we do this? You're open to the idea of the legislation. You just want to get the language correct.
I just want to get it right.
Let me let, we've got one person signed up to speak.
Okay.
And we'll get into the posture of a motion and a second, hopefully, and then we'll offer amendments if that's okay with the representative.
Sounds good, Mr. Chair.
I've got one person signed up to speak, and that's Jill Travis. Hold on, let me get you put on there. Go ahead, Jill.
Hey, good afternoon, Mr. Chairman. Actually, we were just going to speak, depending on what was in the sub, we were just going to speak if it was necessary. So we stand by. Thank you so much for hearing from us.
Well, Jill, since we've got you and you've heard what we're discussing here, we may need to lean in with you in a few minutes to figure out this amendment. But I appreciate you being there.
I'm listening.
Go ahead, Holly. All right. With that said, let's move into a posture. This would be an appropriate time for a motion. Excuse me. Sure.
And I can wait till we get that posture. I was going to try to study this. I know.
I got you.
I do know there was discussion about some differences in this being a lower level act. I don't know, to Representative Bodie's question, speaking as a member, I don't have an issue with the word intent. I do think arouse, satisfy the sexual desires of. I think adding the sexual desires of is a bar that this shouldn't have to clear. I think in the circumstance where, this.
I don't believe that that's where we're headed.
Okay.
I think I think this is what I think here. If we, after the word 16 years, if we add with the intent and strike, and the conduct is for the purpose of sexual arousal, that would suffice what Bodie's talking about. And I think it would be a cleaner read textually. And I don't think it changes any level of penalty.
Chairman,
Yes, go ahead, Holly.
just something to consider, the language, when the alleged victim is under the age of 16 years and the conduct is intended to arouse sexual desire on the part of the alleged offender, consent of the alleged victim shall not be a defense to a prosecution under this code section. That was just an alternate.
Okay, I don't think I have an issue. You're saying after conduct, then you would say,
When the alleged victim is under the age of 16 years and the conduct is intended to arouse sexual desire.
Go ahead.
Her question, I think the term desire is a strong word. I think,
Okay,
and I asked, the reason I make the point, I'm not trying to be, obtuse here, but I think in the Williams case, this 4-year-old child, and we all hesitate to talk about this, but the 4-year-old child said that when her step granddaddy did this to her, it made her feel good. I think there's an arousal thing going on, but to say that raises to sexual desire, I think it'd be hard to prove this 4-year-old had a feeling that could be clarified as sexual desire. I do think that raises the bar too high, I think.
okay. How about when the alleged victim is under the age of 16 years and the conduct is intended to sexually arouse the alleged offender, the consent of the alleged victim, instead of saying arousal on the part of the alleged offender, we could say, and the intent or in the conduct is intended for sexual arousal on the part of the alleged offender, consent of the alleged victim shall not be a defense, because that takes out the sexual desire language and it also puts the language of intent.
Yeah, I think arousal's right. I mean, there are young kids who experience sexual arousal and don't know that it's sexual arousal. It's not a desire as an adult might have that we need to make sure we're covering here.
Chairman, let's think about this here. So if we add the words after 16 years and then right after we add with the intent of the conduct.
I like what you said.
And the intent of the conduct is for the purposes of sexual arousal.
Madam Ledge Counsel stated is probably the best language. The last thing, and I think Mr. Chair, Chairman Ed Sessler agree. I think that was a cleaner version.
Give it to me. Give it to me.
Holly, can you give it to us? I'm sorry, Madam Attorney Carter.
That's fine. When the alleged victim is under the age of 16 years and the intent of the conduct, do you want me to do what I came up with?
Yes.
Would you like me to say that? Okay. When the alleged victim is under the age of 16 years and the conduct is intended for sexual arousal on the part of the alleged offender, consent of the alleged victim shall not be a defense to a prosecution under this code section.
She needs Ed or alleged victim.
Okay. Are you satisfied with that, Ed?
Yeah, Attorney Carter, could you read it one more time?
Absolutely.
And where it says of the alleged offender, add in or alleged victim, because the author does want it to be either or. Because I mean, the facts of the case in Williams was it wasn't ostensibly, they didn't demonstrate it for the arousal of the offender, but it was for the arousal of the victim. That was his whole defense.
Okay,
Just by adding or alleged victim after the alleged offender.
okay, so now with working with that addendum, when the alleged victim is under the age of 16 years and the conduct is intended for the sexual arousal of the alleged offender or the alleged victim, consent of the alleged victim shall not be a defense to prosecution. Is that amenable?
I'm good with that.
Okay. Yeah, we'll have to change it again
Yeah.
in lines 18 and 19.
Sure.
Okay.
Okay,
I think we've got a, now would be the time for a motion, yes. Got a motion to pass? And we got a second. All right, do we have any discussion? Any amendments?
I mean, it could be the Setzler amendment. I'm fine with that, Mr. Chair.
I was hoping to second the Bodie amendment. Either way. Mr.
Well,
Chairman.
if you want to, yeah, and
Okay,
Mr. Chair, if I hope I don't have to go through that whole rendition with Madam
you
Attorney.
started this, Bodie. Come on now. You started this, so.
I wasn't writing it all down, but I'll try.
Okay, so we're gonna call this the Bodie amendment.
Yes.
We consider this a friendly amendment.
Yes.
So give me the language that you're intending to amend.
So on lines 12 through 14, and I'll just read out exactly what we have. And when the alleged victim is under the age of 16 years and the conduct is intended for sexual arousal on the part of the alleged offender or the alleged victim, consent of the alleged victim should not be a defense to a prosecution under this code section.
Okay. All right. And then is that the entirety of your amendment, or you want to amend these other?
Yes.
Okay, good.
So this would be voted amendment.
Hold one.
Mr. A very subtle
Okay.
remark. I'm following the language that Let's Counsel has on line 13. Very subtle. Part of the alleged offender or alleged victim. They didn't put another "the" in there, and I don't know if the
Okay.
"the" in parallel structure creates a difference in meaning or not. I just would want to follow that. They've got grammar experts that get the "these" right.
Where was that, Mr. Chair? I apologize.
When you said on the part of the alleged offender or alleged victim, you
Yes.
said of the alleged offender or the alleged victim. I don't think there's a second.
Okay.
"the."
Okay, so no
Yeah,
second
part.
the.
Okay.
All right, so do you want to, let's restate it again in lines. You want to make the amendment also for 18
Yes.
through 20, correct?
Yes.
So restate it again for me there, Representative Bodie.
Lines 12 through 14 again, when the alleged victim is under the age of 16 years and the conduct is intended for sexual arousal on the part of the alleged offender or alleged victim, consent of the alleged victim shall not be a defense to a prosecution under this code section.
Thank you.
And Mr. Chair, the second part of my amendment, I'll try to follow it closely as well. When the alleged victim is under the age of 16 years and the conduct is intended for sexual arousal on the part of the alleged offender or alleged victim, consent of the alleged victim should not be a defense to a prosecution under this code section.
Okay. Is that the entirety of your amendment?
Yes, Mr. Chair.
Second. We got a move and a second. Everybody in favor of the Bodie amendment, signify by saying aye. Any opposed? All right, so we got a motion on the table for due pass with an amendment by Bodie. I've got a light flashing here. Representative Smith?
Mr. Chairman, I just wanted to bring up, and I may need to lean on PAC, if we could call them in. I think there may be a concern that and if we insert the word intent, there would be double intent that would have to be proved in these cases. So I think there may be a part of this code section where intent already has to be proved, and whether we'd have to prove intent twice or if it's just duplicative. If the chair would be okay with that, I don't know if anybody from PAC had signed up to speak.
Is PAC out in the hallway?
I think I saw Robert out in the hall. I can grab him.
Let's get him in here. When the alleged victim is under the
What number you got?
This is number 10. I'm hiding the back where I'm safe.
Introduce yourself, please, and let me know what you got to say here.
I'm Robert Smith. I'm the general counsel of the Prosecuting Attorneys Council. Basically, then to Representative Smith's point, you've now put a second intent into the crime.
Mm-hmm.
And so basically, now remember subsection B of sexual battery requires that the state has to prove that the defendant intentionally touched the victim. And for this purposes, not only would the state have to prove beyond a reasonable doubt that there was an intentional touching, but that the offender, when they had the intent to touch the victim, their intent at that time was for sexual, are we at arousal, gratification, arousal? They did it with the intent for sexual arousal of themselves or the child when they intentionally touched the child. There's a lot of layers that you put into this, but just this is your policy. This is how you create the legislation. I'm just telling you the practical aspects that now to prove this crime, we're going to have to prove that there was an intent to touch. There's an intent to touch a specific region or a specific area on the body of the victim. And that intent, when the defender went to touch that region or that area of that victim, was done for the purpose of sexual arousal of either themselves or the child.
Go ahead.
So for example, if there was somebody that, and we're making up examples. So if somebody was to illicitly touch say a person touched a woman's groin area on camera, and it wasn't intended to gratify them. It was intended to humiliate them for purposes of being on camera. Hey, I'm gonna have a picture of me illicitly touching you in the groin area to humiliate you, to make a joke. It's not for my sexual arousal. It certainly wasn't for yours. Do we fall outside of this because of that intent?
Oh, because
for sexual arousal.
Yeah. What you've done, because this is only specific to the victims being under the age of 16. If you did this to a adult, then yes, you have sexual battery. But if in your instance, if the victim was 15 or younger, then you would not have sexual battery.
Okay. It gets back to this issue of how we construct this. I know we had brought into subcommittee yesterday, I had an amendment that wouldn't have taken this intent approach, but would have taken the approach of an exemption for, the reasonable hygiene and medical procedures of parents and guardians. Does that present other problems if we perfected that approach?
To be honest, yes, sir, Mr. Chairman, that does, putting in the exceptions, because once you start creating a list of what is and what is not covered, then there's an assumption by the courts that if you don't put something in the list, your intent was not to have it in that list. Go back to the original language, the substitute that was brought before you, where it talks about purpose. It got muddy, it got confusing when you use the word intent. And the only reason why the issue came up is intent has a different meaning in the law rather than purpose. And and because words matter, the placement of commas matter. That's why using purpose, that's different than having to prove intent. And
It's a term of art, and we're adding now to the burden in improving this up.
And that is a policy decision. And if you choose to do that, then the state, as in all instances, gladly accepts our burden of proof, and we will move forward on those cases where we believe we can prove it beyond a reasonable doubt.
Okay, hold on. I got a couple questions. Chairman Reeves.
Thank you, Mr. Smith. I mean, isn't there the basic level of intent is implied on, I mean, is that not true? Whether we use the word intent or not, there's a level of intent that's implied that is required to be proven. Is that not right?
Yes, sir, it is.
So this basic level of intent that would accompany this, whether we use the word intent or not, the state's burden to prove intent is still a prosecution of this offense would be unsuccessful without proving intent, whether it says it directly or not, right?
Yes, sir, because subsection B requires that the touching be an intentional touching. It can't be an accidental. Someone can't throw their arms out in a gesture and accidentally touch someone. It can't be because they have a compulsion or a medical condition that causes them to flail their arms or kick their feet out. This statute, right, because of subsection B requires the touching be intentional. The question that's before the committee today is whether or not there's going to be a second requirement of intent.
And you're speaking is the intent to arouse, sexually arouse.
Yes.
So it has to be an intentional touching. And now with this added language, is it for the intention of arousing either the offender or the victim? Okay, hold on. I got another question. Is that all you had, Chairman Reeves?
It is, yeah.
Thank you, Mr. Chair.
Representative Bodie.
And I appreciate the learned gentleman's opinion. I guess what brings me pause and concern is that this same statute, you know this as well, and Vice Chair Reeves know this. When we take this same statute, when a judge reads out the jury charges, that word intent will not be in there if it's not in the statute, because typically if in my day job as a criminal defense lawyer, I'm going to put up there that the state must prove intent. And so when you put intent up on the chalkboard or whatever we use in courtrooms right now, Elmo or PowerPoint, that word is different to a juror than purpose. If you got purpose and you got intent, I know it's a play on words for us as lawyers, but it means something to jurors. And so I don't think purpose, even though intent is implied, I think it needs to be in the statute so that jurors can be crystal clear on the burden of proof for the state. And that's just my opinion. Thank you.
Chairman Sessler, go ahead.
Thank you, Mr. Chairman. To PAC, getting back to this idea of, I mean, I'm pausing midstream in this conversation myself because I'm sort of catching myself maybe and making an error. I believe that a sexual battery is defined as a high and aggravated misdemeanor as opposed to a misdemeanor because certain spots are more sensitive than others. And whereas a simple battery is an unwanted touch on other parts of your body, a sexual battery is an unwanted touch in a particular part. And it doesn't require, as you said before, it doesn't require an intention for sexual arousal. It's simply you made an unwanted touch on a sensitive area of mine, and because of that, it's a high and aggravated misdemeanor. I guess midstream here, I'm nervous that as we add in the sexual arousal piece to get you out of this with a kid, what if somebody were to touch a child, again, as you had alluded to, it seems like we're giving the child less protections than an adult who's similarly positioned. but for the consent piece. Am I right about that if we were to move forward with this amendment?
There is a,
But because there's a subcategory of behaviors that would be a sexual battery, an unwanted sexual battery that doesn't involve a need to demonstrate intent to please yourself or the other person.
the way I understand it from the amendment I heard in the hall, there is an additional element if the victim is under 16 than if the victim was over the age of 16.
But because the idea is whether you're trying to arouse yourself or someone else, or just humiliate them or be mean or whatever it is, just a malintended touch in a private place is a sexual battery. And if someone has the same malintended touch to the private place of a 14-year-old, you could, there are circumstances where you could very easily not be able to prove I'm doing it for my own arousal or for their arousal. I'm doing it just to be mean and cruel and to humiliate them or post it on social, for example, that wouldn't get you to the sexual battery. And that's where I'm pausing midstream, Mr. Chairman, saying, and I recognize the idea of exemptions are limited, but you think about hygiene, you think about medical procedures as a potential alternative approach to this. There may be others, but I can't think of others that you'd need to put here. I can't think of any religious ritual that involves this that would be, so there's no interest there. I think it is a hygiene and medical. So I'm stopping midstream, Mr. Chairman, and giving second thought.
Thank you, Ed. Or Chairman Cecil, excuse me. Representative Smith.
Thank you, Mr. Chairman. And Mr. Smith, I appreciate you speaking with the committee about this. I will say this, I am sure not in favor of having to make the prosecution prove intent twice. And I think I understand that's your opinion about what this would do if we changed this to intent.
My understanding of what the changes are being made would require a second proving of intent or an additional element. But as to whether or not I have an opinion on that, that is a decision of this body that I'm not
Sure.
entitled to opine on.
Sure. So I know some of us have probably had some experience with these sort of situations. These cases are very intricate, pardon the phrase, but there are landmines everywhere and for both sides. But I think we really need to pause before we even potentially create another step for the prosecution and making them prove intent twice.
Well, I take the representative's words. I think we do need to be measured in this approach, but the State v. Williams case was exactly saying that you had to prove that, or not prove, excuse me, you had to, it exempts this if you were using as a defense that it was for the intent of sexual arousal of the child, that's not a defense. So that's what we're getting at with this wording. Does that make clear what I'm saying? So State v. Williams is saying that you can't use consent as a defense when they're under the age of 16. And in that case, like Chairman Sessler said, the grandfather was saying because the granddaughter consented, then he shouldn't be, charged with this sexual battery. So how do we approach this? With this language, it seems to me that's exactly what it's doing. Is that not what it's doing? It's not what it's doing.
How I look at it, on one hand, is that you're removing the consent element, putting additional requirement on the state to prove. I mean, it becomes a bit of a balance as well, that you guys aren't trying to tip the scale. You're trying to keep things in balance between the two sides. You know, I am a lawyer. I'm trained to argue both sides.
Chairman Reeves.
Thank you, Mr. Chairman. I would move that we hold this. I know that we're looking at having potentially another full committee tomorrow on 194. And we're at an impasse, I think, and I don't think any of us are entirely comfortable where we are, and we want to get this right. It's important. So I think that with the benefit of 24 hours, we can land at the perfect language on this. And so I think that if we could just hold this for now, it very well may be that we may need to reconsider the amendment. I mean, or maybe we don't. But I think if we just press the pause button on this and revisit tomorrow, we'll be in a better place.
Thank you, Chairman Reeves. I think that's the best thing. You're exactly right. So, Representative Saines, we're going to pause here and see if we can get together with PAC, please. I know you've beat this this bill back and forth, and so that's one of the benefits of coming to Judiciary Non Civil. So I appreciate you. I appreciate your hard work on this bill, and I think that the consensus of the committee is that we're amendable to this bill. We just want to make sure that we get it right. And I don't want to make it any harder for prosecutors in this situation. We want to do exactly what State v. Williams has in mind. So if you would just get with PAC and see if we can get this language, tightened up. All right. Thanks for coming, Robert.
No problem. Thank you, sir.
All right, we've got. Thank you, Chairman Reeves, too. I was at a point there where I was mind blown. So we've got Representative LaHood in hall. If you're in the hall, please come in. House Bill 363. Will you step out there and get LaHood? Is he still out there? Hopefully. Sure. Yes. All right. Representative LaHood, how are you doing?
I'm good, Chairman.
I'm gonna just turn the floor over to you, let you explain your bill, and have your expert explain the bill, and then hear from the subcommittee chair. And if there's any discussion or question, we'll open up to that. So without further ado.
Very good. Well, thanks for having me today, Mr. Chairman, and committee. I'll start by just the disclaimer that I'm not a lawyer, and I don't, does everybody say that? Well, Floor Leader Reeves, I heard your bill in health yesterday, and I know it was your first time in there, and, it went really good. You did great. Hope I can do at least that good in here. House Bill 363 is necessary because of not too long ago, the last couple of years, I believe, abuse of access became a defined term, and it's a type of exploitation against elders. And elders are vulnerable, a lot of them, to this type of crime. And so in a case called Austin versus State last summer, the convicted person was given a lesser sentence because of the rule of lenity. And because there's so many different types of exploitation, abusive access kind of was lumped in and with the different types of exploitation. The sentence normally would have been harsher, but this person got a much lesser sentence because of the rule of lenity. And so what we're doing in this bill is splitting the different types of exploitation and putting them in their proper place so that people charged and convicted of this type of crime can be properly sentenced. And I have with me today William Johnson. He's with the Prosecuting Attorneys Council, and he meets every year, I believe several times a year, with a work group of several departments, including the GBI and others. And this was one of their priorities this year. And because I'm in the senior care business and deal with a lot of seniors, and I see abuse, I see exploitation happen a good bit. And so this was important to me to make sure we get this right.
Thank you. Did you have any testimony you wanted to give?
I can give a quick explanation if the committee would like.
Please do.
Will Johnson from the Prosecuting Attorneys Council. I'm the elder abuse prosecutor, resource prosecutor there. So as Representative LaHood stated, this past summer, the language that we added a couple years ago for abusive access in a case of deception, abuse by or exploitation by deception, the abusive access language was convoluted and applied in addition to the deception language. And what this bill does is it seeks to pull that abusive access out and clarify it as a separate type of elder exploitation. That would be in Section 4. But in addition, the court also applied the rule of lenity and said that the elements of exploitation by deception as well as theft by deception of someone over 65 are the same elements, and applied the rule of lenity and went with the sentencing for theft by deception of a person over 65. So as a work group, we sat down with other prosecutors in this state and sought out the different aspects of statutes that had enhancements for someone over 65 when the crime occurred against them, and where those different elements overlapped. And we are seeking to remove those from the statute so that it would go directly into the elder abuse provision in 16.5.102 and not create a conflict of laws that would result in possibly triggering the rule of lenity. In some instances, moving felony abuse cases down to misdemeanors for sentencing.
Okay, thank you very much. I'm going to ask Chairman Sessler to give a report of subcommittee there and how this bill did.
Thank you, Mr. Chairman. We did have 2 hearings on this. And again, there was, when it was first heard, because as you look at the bill, everything that's happening here is not happening inside the corners of this bill. There's other code section references that it depends on. So we gave committee members about a week to think through that and read through it. And yeah, we were, upon further investigation of the subcommittee, we found that the homework had been done. This was a good, tight bill. It just took some understanding. So, if there are questions to members who weren't in subcommittee, I would ask them to reference 16-5100 and 16-5102, which I think are really essential to really understanding all the things that are happening here. So that was the subcommittee's report, that these things are really being consolidated into abusive access because that's the status that caregivers have, is a different circumstance. And so if people are confused by what they see, they would need to reference those code sections to get their mind around the whole subject matter.
Thank you, Chairman. I got one question here. Representative Saint.
Thank you. And to the chairman's point, I'm generally in a state of confusion when I walk into this room, but is it not true that this wouldn't be as necessary if such individuals were in the care of your facilities?
That is definitely, am I on?
Yes, you are.
Great question. And if I had it my way, that would absolutely be true. And unfortunately, we live in a world where, everyone's motives and moves cannot be controlled. And even under the watch of really good, providers in long-term care settings, these things can happen by, look at some of the names of these crimes, theft by deception, and the word deception is there for a reason, because these are very deceiving type crimes, and where it can look on the surface like there's nothing going on, but there really is, things going on. So, and this can happen. Sometimes these crimes are committed by family members or caregivers. It's usually by someone who's the elderly person is very trusting of. And so I know your question was lighthearted, but it was a good one. Thanks.
Well, I have two less lighthearted ones.
Yeah.
Just to clarify, the access applies to both in the person of the individual and assets of the individual. So access to a bank account versus access to jewelry in that individual's room, correct?
My understanding is yes. Is that?
Correct. 16.5.100 applies to both the exploitation of an individual and exploitation of the resources of that individual.
Okay. And for the benefit of, I know I've had constituents call in relation to this, and it might be of the experts' knowledge base. Is there a state law enforcement agency of specialty jurisdiction when it comes to elderly abuse? I know that there's confusion about that last year correlated to a budget funding. Am I making sense?
There is not. Any law enforcement agency can conduct the investigations. GBI does have specialists that are highly trained in each of their different regions for elder abuse cases and elder financial exploitation. But it is generally prosecuted and investigated by any law enforcement agency.
GBI has a unit, or just those individuals trained in their field?
They have a specific unit.
Okay, thank you.
Or director, but also in each region.
Thank you. Appreciate it.
I failed to thank Chairman Sessler at the beginning of my remarks for your work and your good questions in the committee process when this bill is in your committee. So thank you for that.
Thank you, Representative LaHood, and I appreciate you bringing this measure to this committee. I believe it passed out unanimously at a subcommittee. Is that correct, Chairman Sessler? Okay. I don't have anybody signed up to speak to this bill. Is there any more discussion or questions from the committee? If not, then now would be the appropriate time. Motion to pass.
Second.
We have a second. I'm going to call the question for House Bill 363, LC 338545. All those in favor, please signify by saying aye.
Aye.
All those opposed? It's the opinion of the chair. The measure passes on to rules. I appreciate it, Representative LaHood.
Thank you.
We're going to suspend for 5 minutes. See if I can find the author of this last bill. This is 371. What's that?
This amendment only referenced half of what was proposed. This substitute only referenced half.
They didn't strike this language, did they?
I don't know, I wasn't here, but this is what Tankel and Peterson told me.
Yeah, I was of a mind, there was line 31 and 30 and 31 were supposed to be stricken from this, but.
Why don't we have a come in here and see if we can get it right now and not put on long. Okay. It's just an amendment that was made yesterday, passed, but didn't.
Well, I think 30 and 31 they get made yesterday.
It did not get made yesterday.
It was after.
That's a subsequent change they want.
So you're going to present.
I'm going to suspend for 5 minutes and we'll be right. We'll re-adjourn.
Are you an attorney?
Huh?
Are you an attorney?
No, man, my mother raised me better.
Oh, okay.
Just how Sessler, your subcommittee was yesterday.
How
We were just flying.
That's not his adjective name.
I mean, it was the most Setzler experience that I think I've ever
We only had a chance to do that with one bill, though. It's got to be multiple bills. You have to have the stack, man. We didn't get the stack bill.
If you're telling me that there is a Setzler experience than the one that I experienced yesterday, the Setzler-esque,
Oh, no.
I'm impressed by that.
When we did the prescription drug monitoring, PDMP.
Yeah.
That was the most, we had 4 subcommittee hearings. We had 17 amendments. It's, yeah. That's been a minute, but it's, yeah.
I tell you what I do love. I love amendment intrigue. We don't get that often enough. I mean, one of my favorite moments last term was when you voted with us on the courts bill, the remote courts.
This is the right sentence here. No, that's.
This is not, pretend I never showed you this. This bill is not, this bill doesn't have any legs and it's not being heard. There's apparently supposed to be some changes from this one that never happened.
This is, this.
Here's 259. I don't think anybody, that's an irrelevant bill.
This was supposed to be. That's the stuff.
That's right. And they're supposed to, in Tam just marked up this copy there and just struck it out. We can probably fix it now, but.
I mean, it's like a joke because we were talking about how, oh, I don't care about the list. Or whatever. So I went down to the front and she's, box, and I'm like, just interview.
Well, this is the, this is ultimately to me. I mean, what we were offered committee yesterday was, let's just take out this intense stuff and sexual harassment stuff.
So when I stopped, that's it's not bad, right? I'm trying hard to include all the stuff.
You want to have
Oh, you're gonna
I
do
think,
everyone?
because what you're doing is
You'll enjoy
Let me
it.
adjourn real quick.
Some folks are a little more open-ended. I did the more definition, question, only one or two reasons, second, first, move to count path.
I'm going to re-adjourn this full committee of Judicial Non Civil. We were trying to get some final language on these last two measures, House Bill 194 and House Bill 371. Those measures both have a little bit more work to do. So we're gonna have a full committee meeting tomorrow. I can't give you a time at this minute because we're still looking for a room. But we'll revisit those and some other measures because we've got some more to put on the calendar. We're probably going to, I don't want to say we're going to have a full committee every day, but we're certainly going to have a meeting of subcommittee or a full committee every day, at least till crossover. So I know you guys have many other obligations, but just shoot me a text if you have a conflict, if at all you could be there remotely. I'd appreciate it because we need to have a quorum and these measures are important and I want everybody's input. So with that, we're going to adjourn and I appreciate your attendance. Thank you.